to this, the aiming device?
Yes. Your Honor, I understand the court's inclination regarding giving the jury an opportunity to actually witness or experience what the reticle actually is, the bloom, the red dot inside of the scope. And of course, our concern is then that may lead, and I can explain why that would be so, why that could lead to the improper use of the scope to conduct an experiment with regard to what can actually be seen through it. And then my way of accommodating this court's inclination and at the same time preventing what I believe would be, well, I can make that argument when that time arises, but there would be an incredibly prejudicial experiment is that to simply put a sticky in front of the aiming, the sight system, and then that way they can still see the reticle. They can experience what that is, and at the same time, they're not in a position to conduct any sort of visualization about what you can actually see, the field of view, through the aiming reticle. So that was my, that was my accommodation for what the court's inclination was, and at the same time, it would prevent what I think is an improper experiment by the jury.
I concur with Mr. Polis.
Okay, Judge, the whole point is not to see the little red dot inside the device, but the fact that you can, in fact, look through the device, put a red dot on somebody, and still see around the device. I mean, that's the whole idea of this. And by putting something over the end, they can't even see that you can put a red dot on somebody. I mean, they don't even see, they don't really experience what the device can do and how it works, how it's not magnified, which is an important thing, that it's not magnified, that it places a red dot on somebody. And that's the whole purpose of introducing it, is to let them experience how this device works. And so we would not agree to putting something over the end so you just see the red dot inside the device, because that doesn't accomplish what they need to know to be able to make an informed decision in this case.
Your Honor, I'd like to cite the case United States versus Birch, 39 Fed 3rd, 1089, 10th Circuit, 1994. And this is a quote from that case. Where an experiment purports to simulate actual events and to show the jury what presumably occurred at the scene, the party introducing the evidence has the burden of demonstrating substantial similarity of conditions. They may not be identical, but they ought to be sufficiently similar as to provide a fair comparison. There's so many variables in this case with regard to the way in which a scope is used. Everything from lighting, the stress, the location of the scope, that to give these jurors an opportunity, and Ms. McGinn had indicated earlier she would like the jurors to actually place the red dot on a person. And what that suggests to me is what happened in the preliminary hearing, where Ms. McGinn slowly turned in a way to try and suggest to the jury that this is what you could see in this well-lit, calm of the courtroom. This is what you could see through this sighting system. And again, what happened on that mountainside is very different than the conditions in this courtroom. That's why I want to be able to find a happy medium, that is, if the court is concerned and inclined to allow the jurors to see the dot. I can agree to that to the extent that they don't get to conduct what will be an experiment which is not substantially similar to what happened in this case, so they cannot make a fair comparison. And then, of course, I do not want the jurors to then go into the jury room and conduct their own experiments of what you can and cannot see, because there just simply isn't enough here. The other thing that also exists, and I think this witness spoke to it, is that if you have two eyes open, you can see, basically, binocular vision. You can see your own field of view. As Detective Stone testified, because he learned, again, this I think goes back to anyone who learned how to shoot on iron sights, you're just going to close your eye because that's who you are and that's how you shoot. There's this presumption here the state is making that Officer Perez shot with both eyes open. So once again, the jury's going to be misled into believing, well, this is what I can see with both eyes open, even though the facts may be that Officer Perez looked through one eye and looked through the reticle and saw something very different than looking with both eyes open. So there's where this, again, for me, this is this very critical issue where we could end up with a mistrial, that this substantially inaccurate experiment is allowed to occur without any controls to make sure it is truly a fair comparison of what happened on that mountainside and that somehow you can recreate it here.
It seems to me that the solution is a limiting instruction, Your Honor, to say that why it's being offered so that they can see how you put a red dot on someone and what you can see when you put a red dot on somebody, but they should be cautioned not to caution that the lighting and the circumstances in the courtroom are different than on the mountain that day. And so I think it can be handled with an instruction.
The way I want to handle it is as follows. The limiting instruction for the jury would be that this item of evidence was entered for demonstrative purposes. I think the witness demonstrated how this device works appropriately before the jury, before our recess. I'm not going to allow them to handle the exhibit because there are too many variables that can't be recreated, and I don't want to create a situation where they'll handle it and get misinformation about how it may have been used.
So they aren't going to be allowed to look through it to see what the red dot looks like, Judge?
Correct. They were shown how it works. They were shown where the red dot would be. They're explained how it compares or how it works as an aiming device, and that it's more accurate than, forget the terminology that was used.
And Judge, would you not even consider letting Detective Stone walk in front of them so they can look through it and see how it works? Because
he did present it to the jury. That's how I'm going to handle it.
So your answer is no, they will not be allowed to look through the aiming device?
They cannot handle it. They cannot conduct any experiment because, as I mentioned, there are too many variables. We don't know how it was used. Someone could look through it with the right eye. Someone could look through it with the left eye. We don't know what distance it was. That's the rule.
All right, Judge.
Let me just get clarification. So, is there a preference for written instructions to explain why they won't be able to have that back there, or just for me verbally explain?
I think you can explain that to them, Judge.
What I didn't hear.
Explain why they aren't getting it back there.
Explanation as opposed to a written.
I don't oppose it at all.
At this point, it may seem, again, based on the court's ruling, if they're not going to receive it, then I don't know that they need a written instruction, but that's my initial.
My only thought is if they request it, they might want to see it, but if I just orally tell them right now, that might take care of it.
Okay, that'd be good,
point.
Judge.
Good point.
Or I was going to say you could wait, and if somebody does request it, say, sorry, that was just a demonstrative exhibit for the courtroom use only.
I don't mind indicating now when they come in that that was an exhibit that was used for demonstrative purposes and will not be handled by the jury.
All right, that would be great, Judge. And the other thing I want to take care of just before they come in, since Detective Stone has gone on a long time, we wanted to lay a record for our life-size blow-ups. And if I can just make an offer of proof rather than have Detective Stone testify, we had Detective Stone get heights for all of these officers, heights and weights for all these officers, and the blow-ups were made with all of those heights and weights. And if Detective Stone were to testify, he would say these are fair and accurate depictions of blow-ups of the photographs to their same heights for all of the officers, all 19 officers that we had blown up. And I would like to mark for our offer of proof. $73, Judge, would be his testimony on the heights and weights of all of the officers as an offer of proof.
Okay, so 73 will remain with the record as the offer of proof with regard to the height and weight of the 19 officers here. For the 19 officers.
Okay, thanks, Judge. We can go ahead then.
What we're going to do. aim point scope is 54C.
Yes, Your Honor.
Thank you. May be seated. Welcome back, ladies and gentlemen. With regard to the last exhibit, 54C, which is that aim point scope that was displayed, that exhibit was entered into evidence for demonstrative purposes, and the witness's display of the item, an explanation, but it won't be handled by the jury. Detective, you're still under oath, and Ms. McGinn, you may continue.
Okay, Detective Stone, can you tell me about the crime of resisting arrest?
Yes. Resisting arrest consists of when an officer deems it appropriate or that someone who's in contact with a citizen has committed a crime and is going to place them in handcuffs. We are trained in handcuffing procedures, how to safely approach a person in order to put them in handcuffs. And when someone resists that, basically by saying, if I tell you to turn around, place your hands behind your back, I'm going to place you into handcuffs. And when I go to do so, the person pulls away, pushes away, tussles with me, possibly starts to run away, things of that nature. That's what we would call resisting arrest.
And is that a felony or a misdemeanor?
Resisting arrest is a misdemeanor.
Okay. And between a felony and a misdemeanor, which is the more serious of the crimes?
A felony.
Okay. And then, can you explain assault on an officer?
An assault on an officer is when somebody during maybe the course, it doesn't have to necessarily be an arrest. It can be just during a contact with somebody during any given time out in the public, and when that person threatens the officer and that officer is in fear of an immediate battery or being harmed.
All right, and what kind of crime is that?
As opposed to, I don't know the degree for assault. I do know for battery on a police officer.
Okay, what is the battery is different from assault in what way?
Battery is when the actual assault is committed. So when the officer is actually attacked by the person and physical injury does occur, and that is a felony.
Okay. And if someone has a weapon when they assault an officer, is that a felony or a misdemeanor?
That is a felony.
All right.
And you're talking about aggravated assault on a peace officer. Okay.
Can I just see those exhibits just for a second?
Sure. And this is the question?
Did you go up to the scene where Mr. Boyd had his encampment?
Yes.
And were pictures taken of that scene?
Yes, they were.
Let me hand you what's marked as 18A and 18C, and can you identify those, please?
Yes.
And what are those?
This is approximately the area of where James Boyd's camp was located.
Your Honor, I believe 18A and 18C. Any objection?
We'll get into it, Your Honor. Your Honor, we've already made our objections known to the court in the past about these. So we renew those.
Just note for the record a previous objection.
Just you can show them to us. That's easy. Over objection, 18A and C will be admitted.
Detective Stone, let me put up 18A first. And what, can you describe that for the jury, please?
Yes, so you're right now you're generally looking in a northern direction, kind of up the hill. So the shooting itself primarily transpired kind of behind where the picture is being taken, and up on the hill you're seeing right here is the majority of the area where James Boyd kept his belongings in the camp.
Okay, now you said his belongings.
Yes, as what I believe to be his belongings.
Okay. What do you know about how many people were living up there?
Prior to this date, I don't necessarily know if the other individual I had spoken about was actually living up there, but there were 2 people in the past up in this area.
Okay. Were any of these belongings labeled as to whose belongings they were?
No.
If 2 people were living up there, is there any way to know whose belongings were up there?
In the exception that I know some paperwork was found belonging to Mr. Boyd,
Okay.
and there was also various...
Counsel? Let me have you approach.
Okay. Let me just show you this one first. When Officers Hernandez and McDaniel came up, they described him as sitting under something. And let me show you 18C. Does that help you explain to the jury what he was sitting under?
No, not really, not from what I recall. I believe he was under some kind of blue tarp.
All right, so okay. Let me go back to 18A then. There are markings around this photograph, and you see this rock behind this camp. There are some orange stickies on there.
Yes.
Do you know what those are?
The orange stickies were placed there by the criminalistics detectives to mark those particular white marks.
Could you know why they marked those marks on that rock?
Due to the fact that they appeared to be strike marks from a bullet.
All right. And here, there's like a yellow flag K1 and it looks like a P3. Were those there before the shooting or only after the shooting?
No, they were there, again, placed there by the criminalistics detectives.
Okay. And what is that we're seeing in that picture?
Those are cones marking specific items of evidence to be collected. As I had stated earlier, the evidence will be marked in a series of letter number combinations, as you can see, K2 or P3.
Okay. Was Mr. Boyd wearing anything that was collected into evidence?
Yes, his clothing.
All right. And did he have anything on him in some kind of pack form?
Some kind of what form?
Pack, like a pack?
I'm going to object to your irrelevance.
Of what was on Mr. Boyd?
Right, yes, in a pack form, relevance, Your Honor.
I'm going to overrule the objection.
Okay.
Yes, he had a form of like a black, like fanny pack type thing.
Was that collected as evidence?
Yes, it was.
And why was that collected as evidence?
Because it was on him.
And why would that be important in a case like this?
To see what else that he had on him at the time of the shooting.
All right. And was the fanny pack emptied out to try to determine what was inside of it?
It was done so, but it was done outside of my presence. It was done, all of that processing is done by the criminalistics detectives.
All right. And did they preserve what was inside the fanny pack in evidence?
Yes.
And did you bring that to court?
Yes, I did.
Let me hand you what's been marked as 19C3. And is this, can you identify that, please?
Yes, this appeared to be the context, the content of the contents of the black bag that was on Mr. James Boyd.
All right. And why is it important to know what's inside something that the person has on their body at the time they're shot?
Well, for one purpose, you want to try and identify the person that's been shot, especially if they're now deceased, in the event that the person was lying about who they were. Also, just to see anything else that might be important, because you don't know.
Are you looking for any additional weapons that they might have on them?
Yes.
Okay. Were there any additional weapons in Mr. Boyd's fanny pack?
Not like as far as like a knife or a gun or anything like that, no.
Well, is there any kind of weapon in there?
I mean, there's things in here that can be used as a weapon, but they're not commonly referred to as a weapon.
Are you talking about the barrettes, or what?
Objection to her leading the witness now?
Well, what did?
And objection to him starting to testify to what is in the bag without it being admitted.
Sustained.
Well, I'm disturbed about there's things that could be used as a weapon.
No commentary, please.
All right, Judge. What are you referring to when you say things that aren't commonly thought of as weapons?
Same objection, Your Honor. She's asking him to talk about what's in that bag.
Sustained.
And that's,
Okay. Inside the bag, and if I can direct you to a time when Mr. Boyd at some point during this could have pulled out something from the bag that was not a knife. Do you know what I'm talking about, Detective?
The mace?
Yes, sir.
Yes.
Did you, what did you find as far as the mace can inside that particular bag there?
It was discovered that the mace can was actually empty.
All right. Let me hand you what's marked as 19C2. Can you identify that, please?
Yes, this appears to be the mace can that he had, James Boyd.
And how did you determine that mace can that he pulled out at one point was empty?
Again, criminal justice detectives determined that.
All right. Your Honor, I would move 19C2, and I would also move 19C3, but I'd like to approach to discuss it. As part of collecting the evidence, did you try to collect any money that was out at the scene?
I don't know if you will specifically look for it, but it was out there.
I'm going to object, Your Honor, to, I guess we have to come up again.
Did you take into custody, or did someone take into custody at your direction, Detective Stone, the knives that Mr. Boyd had at the time?
Yes.
And how many knives were there?
2 that he had, and then there was a third.
And the third was where, sir?
I'd have to refresh my memory of the report on the third one.
Please do.
I don't know if it's, I'd probably have to look at the criminalistics report, it'd be easier.
Okay, would it be better to get that information from criminalistics?
Yes.
Okay, and would it be better to, are they the ones that took the knives in?
Yes, Detective Nate Render.
All right, so we will try to introduce those through the Detective Nate Render then. Thank you very much. Did you try to find a picture of Mr. Boyd?
Yes.
Okay, let me hand you what's been marked as State's Exhibit 15, and can you identify that, please?
Yes, it's a picture of James Boyd.
All right. And move 15 into evidence, Your Honor.
No objection.
No objection, Your Honor.
15 is admitted.
Let me ask the juror question. Were you able to tell whether or not Mr. Boyd was had been a veteran or had served in the military?
No, he did not.
And were you able, based on your investigation, to tell if he were suffering from a mental illness?
Yes, he was.
And what mental illness was he suffering from?
Schizophrenia.
And how long had he been suffering from the disease of schizophrenia?
From my investigation, I believe it was over 10 years.
We've talked a little bit about Mr. Thixton. Did you go up and collect the video that he shot while he was up on his balcony?
That video was collected by criminalistics detective Frank Pisano.
Have you reviewed the video, and does it capture from a different angle what happened when Mr. Boyd was shot?
Yes.
And have you reviewed that part of the video to make sure that it is fair and accurate?
Yes.
Okay, Your Honor, at this time, we would offer to play Exhibit 13B and then 13A.
Okay, and B is a board?
Yes, Your Honor.
And 13B.
I don't think I'm going to have an objection, but I do need to approach this really quick to make sure of something on it. Okay? Can I just address one other thing real quick? I think it can be just,
Like 2 minutes.
Right
Right.
Ms. McGinn, just to be clear, you all are not planning on showing or introducing 13C1 and 13C2. It's Mr. Boyd doing the cross.
Not at this time, we're going to do that through Bixton. Right,
Okay, well, you have an objection at that time.
right,
You said 13C1 and
right.
13C1, 13C2, we'll be having an objection to when they come to that point.
She doesn't think they're pulled out.
Yeah. It doesn't say anything. I usually get it at the end.
Can I inquire as to what's happening here?
Yeah, come on, you can, it's, I mean,
I'm not
sure,
used to seeing the
no,
other side
I
of the paper.
usually get these, travel orders, but usually they're filled out, so I'm just explaining to her. I usually get these.
I see, that's fine. I didn't know what was going on. I thought it was like them citizens.
No, no, so, and can I get clarification on the piece that we're discussing and you're looking at? Is it 13A or 13B where it says the questionable noise?
I'm sorry, the one with this, the.
This noise that we're looking for?
It's 13B and then 13A. Yes, Judge.
On both of them? It's
Yeah.
contained on both?
Right, but I think it may not be on there, so that's what we're figuring out right now. I think that we may not have sound, it may not be a problem at all. Okay, we don't have any sound, Judge, so that makes it easy.
No sound on?
There's no sound on it.
And Your Honor, just to confirm that it's going to stop at the end of, at the time the sixth shot is fired.
We've said twice that's going to stop at the time when the fifth shot is fired.
And when you say that there's no sound whatsoever, it's just...
Zero sound. So,
Any objection to 13A and 13B with no sound?
No, Your Honor.
Okay. 13A and 13B may be played and are admitted without any audio. We could bring the jury back.
get it hooked up onto the, with the picture on.
Oh yeah, if you could switch it to HDMI, Your Honor.
And we're doing number B first.
B first.
Okay.
Okay.
Okay, back it up there. Okay.
Thank you. You may be seated. Ms. McGinn, you may proceed.
Okay, Your Honor, we will play 13B for the jury, Your Honor. Okay, stop. And then 13A, Judge, which is in real time. Okay. That's it, Judge. Detective Stone, when you went to collect tapes, either taser cam tapes or audio tapes, from the members of the rope team and the canine team, who did you get tapes from?
Audio tape from Acting Sergeant Rick Ingram.
And who else did you get tapes from? From both canine and rope?
Canine Officer Scott Wimskirch. I got taser footage from him.
All right. Is there a SOP that requires officers to record encounters like this one?
Yes.
And who did you not get any kind of tape from?
I did not get any kind of audio or video from Detective Keith Sandy.
Okay. Your Honor, that's all the questions I have. I'll pass the witness.
Cross his head.
Good afternoon, Detective Stone.
Good afternoon.
I'd like to just reiterate your importance in this case. You're responsible for overseeing the entire investigation of the James Boyd officer-involved shooting.
That's correct.
You're responsible to ensuring that all important interviews of police and citizens actually take place.
That's correct.
You're responsible for obtaining the interviews of all the officers who fire their weapons.
Correct.
And you're responsible, along with the criminalistics detectives, to ensure that all relevant evidence is collected.
Correct.
Now, you're not just simply here to investigate the officer-involved shooting. You would agree you're also here to investigate any criminal activity that you uncover.
That's correct.
You're here to investigate any criminal activity, whether it was committed by a police officer or a citizen. Is that right?
That's correct.
Now, your shooting investigation in this particular case began on March 16, 2014. Is that right?
Yes.
And it wasn't until September 26 of 2014 that you completed your investigation. Is that right?
That's correct.
So you spent approximately 5 months investigating this case. Is that a fair estimate?
The preliminary investigation, all the way up till I turned the case in, correct.
Approximately how many hours did you spend on this investigation?
Over 100 hours. Hundreds, yeah.
You said 100?
Over 100 hours.
Okay. Now, your supplemental report was 885 pages in length. Is that right?
Yes.
How long did it take to write a report of that length?
It took me several weeks. It's important to note that within that are documents and such, things that are attached with the report that I didn't actually type out, but to put it all together and type it all up took several weeks,
Okay.
4 or 5 weeks.
You interviewed Detective Sandy, is that correct?
Correct.
You interviewed Officer Perez, is that right?
Yes.
And you interviewed all of the important officers who were there at the time the shooting took place.
Yes.
Now, there were other detectives who helped you conduct interviews, is that right?
That is correct.
And it's true that you can't be everywhere at all times, is that right?
That's true.
You need other detectives to help you take all of the interviews of all the involved personnel.
That's true.
And that's how all officer-involved shooting and homicide investigations work, that although you may be the case agent, you simply do not have enough time in the day to be involved in every interview of every witness in every one of your cases.
That's true.
And it's also fair to say that you had other cases going on at this time.
Yes.
How many active homicides were you investigating in and around the spring and the summer of 2014?
From what I can remember, probably between 3 and 4.
Okay. Now, although you did not actually participate in the interviews of all the witnesses, is it fair to say that you actually reviewed every witness interview?
I did.
So it wasn't that you reviewed a summary, you reviewed the actual interview.
Yes, I listened to all the interviews.
And in fact, you're the person who actually drafted the summaries of the interviews. Is that right?
In my report, yes.
Now, there were numerous audio and videotapes that were taken in this case.
Yes.
There were audio and videos that were created by the officers on the scene. Is that right?
Yes.
And then there were audios and videos that were created by the Albuquerque Police Department. For example, the radio dispatch tapes, the non-emergency telephone radio tapes, or I should say tapes. Is that right?
Yes.
And is it fair to say that you reviewed all of those videos and all of those audios, whether they were created by officers on the scene or by the Albuquerque Police Department in the normal course of business?
Yes.
Is it fair to say that you know more about the James Boyd officer-involved shooting case than anyone else?
I would say so, yes.
Okay. So I'd like to just simply begin with the interview of Officer Perez, since that was discussed. You did, in fact, interview Officer Perez, is that right?
Yes.
When you asked for Officer Perez to sit for an interview, he voluntarily agreed.
Yes, he did.
And you would agree with me that you had the opportunity to ask any question you wanted of Officer Perez.
That's true.
No one interfered or prevented you from asking any question that you wanted to ask.
No.
And Officer Perez asked answered each and every one of the questions that you asked.
That's correct.
And Officer Perez's interview lasted a little bit more than an hour. Is that fair?
Yes.
And it'd be fair to say that you've had an opportunity to review Officer Perez's interview and compare it with everything you've learned in this case.
Yes.
Is it fair to say that when you compare the statements made by Officer Perez in his interview with all the other evidence you've come to learn in this particular case, that you did not find any contradictions between what Officer Perez told you and the evidence in this case?
Objection, Your Honor. Hearsay, and calling for hearsay, an interpretation of hearsay.
Ask you to rephrase the question.
Did you find any statement made to you by Officer Perez that was inconsistent with the evidence your investigation revealed?
Same objection, Your Honor. Hearsay and ultimate issue.
You may want to approach that.